Welcome to Women Winning Divorce. I am your host, Heather Quick. I am an attorney, entrepreneur, author, and founder of Florida Women's Law Group, the only divorce firm for women by women. I love thinking big, thinking outside the box, creating creative solutions for women, and empowering women to win in all aspects of their life. Our approach at Florida Women's Law Group is to provide women with a strategy to not only achieve their objectives, but win at life. I believe that what may show up as adversity is simply an opportunity to change and improve your life. In each episode, I sit down with innovative professionals and leaders who are focused on how you can be your best self before, during, and after divorce. In these conversations, we are looking at how women can win at life. I have the unique opportunity to meet women when they are at a transition period of life. But that is only the beginning to becoming your best self and winning at life on your terms. With our guests, we enjoy the opportunity to explore ways all women can win and enhance their life, no matter where they are in their journey. Because divorce is just a point in life, not the end and not what defines you, rather a catalyst for your growth. Welcome to Women Winning Divorce. Each week, we discuss issues including divorce, custody, alimony, paternity, narcissism, mediation, and other family law issues to provide insight on the journey of women winning divorces. I'm Heather Quick, owner and attorney of Florida Women's Law Group. And today I have the pleasure of being joined by Susannah Collins. Welcome to the show, Susannah.
Thank you, Heather. Thanks for having me here.
Well, I am so happy to have you. So for our listeners, Susannah is a Florida family law litigator, and we have known each other for years because she is in our local area. And her practice has evolved over the years. So she not only represents individuals in the litigation, but more often now, and you can let us know, Susannah, she's doing mediations and social investigations.
I do mediations about 3 or 4 days a week. I am a court-appointed social investigator. I am a guardian ad litem, an attorney ad litem. I do a lot for children during the entire divorce process. And I've been doing all that about the last dozen years. So my practice has morphed and changed quite a bit over the last 20 years or so.
Well, and that's great. And it's, I think that's the beauty of it, because you find areas within even family law that really are more to your particular skills and experience, or just really where you want to move. And you've been able to really do that with your practice. So Susannah, please tell our listeners a little bit about how you got into family law, and most importantly, why you stay in it.
Well, so I always knew that I would be an attorney. In my family, you were either an attorney or you were a fighter pilot in the Navy. And I could not keep the planes in the simulators above the horizon, so I went to law school. So I knew that I would do that. And for me, family law was the only area of law that I really enjoyed that helped people. And I was very concerned about helping people, all people. And you can tell from the way that my own practice has changed over the years that the people I really wanted to help more than anybody else was the children. So I'm very focused on the children. I've stayed in it because of the children. There have been a lot of upheaval over the years. Especially with COVID, with people living together, we've seen such a change in family law in general, but the children still need help. And so for me personally, being a family law attorney allowed me to focus my skills, my talents, my efforts, my education, my knowledge on helping children, helping people get through the process without harming their children, or without, with minimizing some of the harm to children. So that's really why I've stayed in it over the years. Well, and
that's great. You know me, I don't want to help all people, just women, right? No, but and the way I see it, we help women, then we help everybody in the family. So that's just
sure. I agree with that. And I don't represent just women or just men. I represent both men and women, but I always want to have a focus on the children. I really do. So.
And that's so important, and really does tie in to the topic today, which is so very important. It's evolved over the years. I think that, there's a lot of people don't understand. I know that about what is now termed a social investigation. And, you and I still remember when they were custody evaluations, but I don't think the law likes the word custody anymore. I don't know why social investigation sounds better. It sounds so much more clinical, but maybe you can, have insight on that. But I think what would be great is if you can give our listeners
some background. Like, what is that? What does that even mean, a social investigation?
Okay. Well, interestingly enough, so people always talk about custody, but in Florida, we don't have custody anymore. We just don't use that word. We talk about two different things when we talk about children. We talk about parenting, parenting responsibility, and we talk about time sharing. And time sharing is really the time, the overnight time that we share with our children. It's more politically correct than saying visitation. So that's what we all
I
grew up
know, and I
saying.
think you're right, because when
Yeah,
you just termed it that way, right? It seems like visitation is something you do, in the hospital or the jail, right?
exactly.
So we
It's
don't
more,
want to talk about our kids like that.
sure, it's more like babysitting as opposed to sharing time, sharing, the joy of child rearing with your children. So that's the time sharing aspect that we talk about in family law. The other side of it is parental responsibility. And the parental responsibility is really, generally speaking, in Florida, shared between the parties. It's public policy, it's codified under public policy law in Florida that both parents get to share time with the children. Both parents get to be involved with the children. They both get to make decisions for the children, where they're going to go to school, if they're going to play soccer, if they're going to go to church or not go to church. All of these things that parents do for their children and decide together for their children, they get to continue doing that as though they were in an intact marriage, and that's important for the child. So we have that aspect of what used to be called custody. We have this parental responsibility, we have this time sharing, and so we don't call it custody evaluations anymore, just because we've kind of X'd that word out of the lingo in Florida, as it were. So social investigations are just kind of like these investigations that are into all of the social aspects for the child, because while it helps mom and dad get through the process, it's designed to help the court decide what's in the child's best interests.
Okay, you explained this helps the court, and really, what is it?
Okay, so a social investigation is when a person like I, who's an attorney, an officer of the court, a psychologist, a therapist, a licensed clinical social worker, etc., some neutral third party who's appointed to a case to come in and do the things that the court can't do. The court cannot bring in all of these other people to kind of fix the he said, she said between the parties who are testifying in court. He did this, she did that, she's a terrible person, he's crazy. All of these things that are said to the court doesn't have the time, the calendar, the resources to go in and investigate all of these things. And so a social investigator is someone who's appointed, who can talk to both the parties, talk to the child. In Florida courts, we don't allow the children to come in and testify unless it's a criminal action. So the courts don't have the children come in. So I, as this neutral third party, can talk to the child. I can visit with the child in mom's home, visit with the child in dad's home. I can talk to neighbors, counselors, therapists, school officials, coaches, grandparents, all of these people that it would take the court days and days and days and days to talk to. And I can do that and provide a report to the court, which says, here's what I'm told, here's what I'm seeing. I'm reading all of these text messages and exchanges, and I'm looking at the child's report cards, and I'm talking to coaches, and I'm seeing all of these other things that the court maybe not doesn't have the access to. And I can do all of that and prepare a report for the court that says, here are my recommendations. And my recommendations, while I'm looking at all of these things that are presented to me, my recommendations are based on Florida law. So there are a body of Florida laws, I should say, in Chapter 61 of the Florida statutes, which says, court, when you are evaluating what should happen with the children, and this is my word, my language, not the statutory language, but court, when you're looking at what is in the child's best interest, where the child should live, who should be responsible for this or that, etc., here are all the factors that you are supposed to apply. And there's no way for the court to look at all of these factors without having someone neutral who goes in and says, court, let me help you compile all of this evidence to make the best conclusion that you can possibly make for the benefit of this child. So that's really what I do.
And really, I guess, when this is necessary, and we're going to talk obviously throughout the show about this, but there's just going to be a dispute, right? I mean, this only comes in place when there's a dispute over the time sharing, what most lay individuals think of as custody.
Correct.
Until they meet with an attorney and understand it's a different word. But that's usually when it's going to come into play. If they have an agreement on whatever that will be, there's no need for a social investigation, right?
Yes, you are correct. And the social investigations are really ordered by the court when there are disputes that are much deeper than just I want more time, you want more time. It can be when a case is long and drawn out, when there are a multitude of pleadings, a multitude of allegations about mental health, allegations of abuse, allegations of drugs, allegations that, well, anything. But when there is a dispute over the parenting plan, which is this incorporation of all of the things, that's a legal word, things, I'm air quoting. When there's a dispute over all of these things that make up a parenting plan for the child, that's when the court can order a neutral third party to go in and help make decisions for the child. So yes, it's not, if a party's divorcing and they work out something for the child, generally speaking, the court will not set that aside. The court will not order a social investigation, because the court really wants the parents to determine what's in the child's best interest. So I only go in if the parents can't agree and the court doesn't know what to do.
And I have found these to be very helpful, as to having this third party, because we as attorneys, okay, I can question the husband and we can also question the witnesses, but we can't question the children. We don't. I certainly wouldn't, right? And get that neutral information that you do. It can really help, I think, a lot of individuals settle, maybe because now they know, hey, this independent person is going to come in and this is what they're going to report to the judge, who is going to listen to that. I mean, I find the judges really appreciate the objective opinion based on what they've learned through their investigation.
You are absolutely correct. You're absolutely correct. I will tell you that 95% of the time, the judges will do exactly what the social investigator or the guardian ad litem or someone else who's a neutral person recommends that the court does. And it's because the court cannot go as in depth as this person. But it does help settle cases. It does help manage expectations for clients, because they are going to know what's going to be said. So when the reports are done, by statute, the reports are supposed to be filed on the court docket, given to the attorneys, given to the clients if they're not represented, and they will know what the recommendations of this third person are. It does help settle cases. And of course, when parents can settle cases on their own, they have a lot more flexibility than the court does. And they have a lot more interest in doing what's in their child's best interest. So you're right. It can help settle, and it can help make the job of the attorney better as well.
Yeah, absolutely. Because, you're able to provide, which, you indicate everything you do, which is you go to the different parties' houses, and you can view interactions, right, with the children, with their parent. And you can talk to witnesses, because each party has an opportunity. Mom say, hey, I want you to talk to these people, and dad, you want them to talk to those people as well, right?
Correct.
And but then not only do you do that, I mean, you have a written report that is going to really provide a lot of detail as to what you found. And then, I know yours does, like, I've seen them before, every factor, and hey, who is this in favor of, or what does it show the court, right?
And I'll tell you something, Heather, just to kind of expand on that a little bit. So the last two reports I finished one last week or the week before, and then one just the week before that. And I'm working on one right now. Both of those reports probably took me about 60 to 75 hours of work, and they are both about 140 pages long. The one I'm working on right now, I haven't finished, and I'm over 100 pages. So if you think about the totality of all that goes together to compile a 100-page document, 140-page document, that is something that the courts could never do. They could never spend 60 or 75 hours on a family law case.
No, because, which we're gonna, as we continue talking, because it is such a time saver, that, but with really in a valuable way, because here you as an individual can compile all this information, present it in a way that is more consumable than 30 witnesses. I mean, you just don't and the cost to have a trial that would take at least a week, maybe two, is just, most people really don't, I think, can't really understand how lengthy it will be and costly. And then really, how much of it is the judge going to, in all fairness, really listen to, right? I
You're
mean,
correct.
the court's gonna be like, listen, you have given me all these witnesses, they're saying the same thing. They may say, I'm not going to hear anymore on that. And that can be a little bit detrimental to your position sometimes when you just want to inundate the court with so many witnesses. And I've been in that, situation. That time management is difficult.
It's
Courts
certainly,
just don't have that much time.
and it's cost prohibitive.
It really is. It really is. And witnesses get nervous. They may or may not say what you think they're going to say. They may have a hard time expressing everything because of that pressure of being in a courtroom in a hearing with everybody looking at them versus being able to have a conversation with an independent person and you being able to weave that in to all the other facts.
You are correct.
Well, we are going to take a short break. When we come back, we're going to talk about what you would do in a social investigation, especially in the courtroom. And, while you wait, we encourage you to visit womenwinningdivorce.com to subscribe and check out our resources. We will be right back. Welcome back to Women Winning Divorce. Today, we are discussing social investigations in modification and relocation cases with Susannah Collins. And before break, we were discussing what a social investigation is and when and why you need one. So if you enjoy the content so far, please leave us a review so other women can find this as well. So Susannah, all right. Now, if you don't have an expert in a case, right? I mean, basically, who does the judge have to rely on in order to make a decision?
That's a big question. It's true. If there's not somebody else, how does the judge parse through what he says, what she says? It's really, really difficult. It's a great question. They need somebody.
And also what I know, I've said this before and it's just because it's true. So many individuals and so many of our clients, they have no idea what to expect. They're only most people's understanding, unless you've been in a lot of litigation or are a lawyer, is really what you've seen on TV as far as the drama in the courtroom and things seem to move really quickly and they're able to achieve a lot, right? In an hour show, even in a 2-hour movie, they accomplish a lot. And, in the reality, I mean, if you have 4 hours before the judge, that's really barely enough time for the husband and wife to each testify, right? It goes so fast.
You are correct, because each side only has half of the allotted time. So truthfully, you're correct. And, and it's funny when you talk about experts, people are very quick to get an expert to help them look at finances of the husband's company, or look at an appraisal for a house. All of these other things are quick to look at that. But people are not so quick to get someone coming to the court who's going to talk about their children, talk about what's in their children's best interest. It seems like this kind of far-fetched idea to some people that they've got to have this expert witness to come in and help them. And truthfully, it's the most important thing. I mean, it really is. So yeah, so a witness helps people. And you're right. You don't have a whole lot of time you go before the court. I mean, a 2-day trial is not that much time.
It's really not. And, think about that, a marriage and 2 or 3 kids, just even one child. And if you are relying on just what you have to say and what your husband has to say, that leaves a lot out there, because, we were talking in the earlier segment, I mentioned, witnesses can be nervous. Like, it's just a snapshot of who you are, and you're trying to do your best, present yourself in the best way. But the judge is a human being, and they're going to just determine, hey, and that's really what they have to determine. Do I believe her more than him? Do I believe him more than her? Or gosh, they both seem like nice people telling the truth. So what are they gonna do? Can't split the baby, but split the time, right? They're just gonna.
That's exactly what happens, because if you don't have somebody who is this neutral third party who's gone in and done the actual work and the actual investigating, then you've got to rely on a judge who thinks that one party is more credible than the other party. Holy cow. And we all know that there are people who might present really, really well, and they're not that truthful. They're not, really even that nice of a person if they're not in that situation. There are all different sides and facets that everybody has. And if you get this neutral third party to go in and see them in their home, in other scenarios, you're reading exchanges between parties, you're looking at all of this different information, it kind of takes that credibility factor away from the court. There's a third party saying, here's what's really going on, judge. Here's the behind the scenes skinny. And that's important. I mean, it's really important.
It is, because that's, I think, where you really just, it doesn't come across in that short period of time, you know,
Right.
in reference back to the TV and the movies. Well, yeah, you know, the guy's a liar, or you know, I say the guy's a liar, or the girl's, you know, a liar, but you know he's lying, right? You always know he's lying, and you can tell because it's written, it's a drama for your entertainment. And in real life, yes, we all have, you know, maybe radars, but that doesn't mean, even as the attorney questioning somebody, that I can get out enough that's really going to sway the judge to say, you know, the children, it's not in their best interest to spend this amount of time with their other parent that he wants. And that's, you know, our, not a big obstacle, but I think when you have these cases, it's a struggle because the parents see things so differently.
It's true.
And that's why, you know, having somebody in there, and sometimes also, you know, they can hear also from you, because you're going to ask them questions, right? I mean, I assume, I haven't ever been in the, you know, in that part, like where you're talking, but you're going to ask them a lot of questions that hopefully they're able to answer freely, but then they can maybe learn too, oh, this is what these decisions are going to get made based on, right?
Sure, of course. But you know, I will tell you something too. A lot of people can't afford attorneys. And a lot of women can't afford attorneys, Heather. I mean, I hate to say it like that, but that's just the truth. And, you know, sometimes they just get to that point where they say, I can't afford this, I can't afford that. And so if I could talk for a second, I want to kind of tell a value to a social investigation that you may ask a question about it later, but I'm going to go ahead and get on it if I could, if you don't mind. So Heather, you know, there are rules of evidence. There are ways that we get information in front of the court. And sometimes we just can't get it all in front of the court. And it's really, really difficult for people who, and it's difficult for attorneys. I'm not going to say it's just for pro se litigants. It's difficult for attorneys to get things out. And I often tell clients, we might know something. We might really know it, but how do we prove it? How do we get this or that in front of the judge? And so, you know, one of the benefits to a social investigation is that unlike a guardian ad litem, unlike some other appointments that the court makes, the social investigator doesn't have these rules of evidence that apply to them, that apply to the report. And that's really, really important for a lot of people. So for instance, when I, as an attorney, want to get a Department of Children and Families report in front of the court, I have to call in the investigator, the caseworker for the Department of Children and Families. I have to have this person come in and testify about this report they wrote. If there is a police report, a domestic battery, a DUI, something like that, I have to have the police officer come in and testify about what he or she saw, what they wrote about, to get their report in front of the judge. As a social investigator, I get to look at all of that stuff. And when I testify to the court, I get to say to the court whatever I want to. I get to use hearsay. I get to talk about the documents. I get to talk about anything I saw, anything I read, anything that was said to me. So when people say to me, oh, well, this is a hearsay statement, I know I can't say that. Well, guess what? I can. And so for people who maybe don't have a lot of money, they're spending all their money on their attorney, they don't have extra funds to start hiring experts and start hiring other people. This one person, this social investigator, can get all of this evidence in front of the court. And that's a really, really powerful tool for people.
I completely agree with you, because I've talked to, you know, clients over the years, maybe afterwards, after they've been to a hearing, and they're like, well, I had all these doctor reports, right? I had the police report, I had the school report, and I mean, hey, they didn't go to law school. I'm like, I know that, but you don't get to just show paper to the judge
right.
in that case, but you as the social investigator, you can read it all. And then you can take all of that information and help to make a decision, which is so valuable, because very often it's cost and time prohibitive to do all that, versus if one person goes through it all and then condenses it, synthesizes it, it's such a better delivery of really what's been going on in that family.
Exactly.
That may otherwise not get presented.
You are right.
All right, I have another question I wanted to talk about this, because it hasn't happened to me that often, but it has. The issues don't come up a lot, but they do, where, well, you know, I think my child should testify. And people think that, and, you know, and they say, well, what's the age when the child gets to choose, right? I know you've heard that. And
every day. And you know, and there
yeah,
is no age. People say
I
to
know.
me, oh, so my child's 12, he gets to testify. My child's 14, he wants to have his day in court. My daughter wants to, no. Until they're 18 years old, they don't come before the court. And, you know, we had a really great judge. We still have a really great judge on the bench. And I asked him one time, I said, you know, why is it that we don't ever want to hear from these kids? These kids really want to testify. They really want to say what's going on. And we might have only the child in the house to testify. And the judge said to me, well, what if dad just offered him a Mustang if he testifies about what dad wants him to testify about? And I thought, ooh, wow, yeah, what if? So, you know, there is so much that can come into play with a child that, you know, it was kind of an enlightening a way to put that. But the courts don't want to involve the children in family disputes. The court doesn't want a child to come in and say, I'd rather live with mom, I'd rather live with dad, because psychological testings, evaluations, articles that are written, all these things say that when a child gets older and he's done that or she's done that, it has far-reaching implications. Not only can it destroy the relationship with a parent, it can destroy that child's trust factors, all sorts of things. It's just really, really a terrible thing to do to children, to put them in the middle of any kind of custody dispute, even though I'm not supposed to use that word. So we want to keep the kids out of it, but a social investigator gets to go in and talk to the child and tell the court what the child said. So it's really a voice for the child. It's really the way that the child has not his own attorney, but somebody who's looking at the totality of all of the information and saying, here's what the child is telling me, here's what the child is saying, here's what the child has confirmed or denied or is saying. And that is a voice for children that they don't always get in the court. And that's pretty important.
Yeah, I think that's really important because it, in either side that may want the children to be there, it just has far-reaching implications.
Yeah.
And I know there are cases, because you can have a motion before the court can decide, but it, you know, I've had cases where one party wanted that, but then they did kind of back it up because the judge really made them think a little bit more closely about that. And I know some judges in the past have said, hey, yeah, I'll talk to them.
Sure.
You know, in their chambers and depending on many factors. But I think if you can avoid that, it should be avoided, you know, for sure.
I agree. And it's, you know, Heather, it's not done as much as it used to be done. I feel like the older judges would still have the kids come in. And really in the last, I would say probably 10 years, I've had it happen one time. And the child was almost 18 years old. And it was something that really only the child could kind of testify about. But it was done in camera, which means nobody else was around. It was just the judge and the child and a court reporter taking down the information. No attorneys were even allowed to be in there. But it was just so the judge could get a little bit of insight. So
yeah, and I think you're right. The age, of course, is going to come into play in a lot of things. But and really, it was probably the same judges that were more open to it, but not very often. Well, and not very often. We have cases at our firm where we would, even if our client wants it, you know, we would then go that route to ask the court because we don't know what the child is going to say. I think in order to protect our client, we should go a social investigation route first and then determine if that's necessary or not. But that there are so many other avenues, which is exactly why we're talking about this. You can get the information really better ways, like you said, right? That children can be, and particularly as they become teenagers. I mean, normal teenagers are very, you know, focused on what's in it for me, right? That's a normal teenager who's really thinking more about themselves. And so if they are easily swayed by either parent, that could really have detrimental results for them in the long run.
But you know, there's more to it than that even. So if the child just had a fight with dad that morning, if dad's more permissible than mom, if mom's the heavy hand, you know what I mean? And you know, we got a teenage girlfriend who wants to go see her boyfriend and dad says absolutely not. And mom says, I really like him. Yeah. All of these factors come into play. So yeah, I mean, I think it's a very tenuous situation if a court brings a child in to testify. So not only the implications to the child and the child's psyche, but just is the court going to get really accurate information from a child? Yeah.
Right. And I think that does, and that can be under any age. I mean, certainly, you know, it's not going to be entertained for children who are too young, but too many external factors really are going to be in play, and I think another reason that we shouldn't involve them. And also when you are doing your investigation, let's say the children are in counseling, have you had instances where then you are you get not only records or have an opportunity to talk with their counselors as well?
Yes, absolutely. And the counselors are always very happy to talk to me. I've never had a counselor not speak to me. The counselors are very cautious about what they say because they don't want to violate the patient privilege with the patient, even if they've got a 5-year-old or 6-year-old. They want the child to be able to trust them, but they know that they're not coming into a situation where there's going to be 2 attorneys asking questions, having them on the stand, grilling them, things like that. They're talking to another person who's been appointed by the court as a neutral to do what's in the child's best interest. So I've never had a therapist refuse to speak to me, which is fantastic. But I get so much more insight into the child, what the child needs, what the child may be expressing, and things that even the child doesn't tell the parent. So the children get to this comfort level, and it's nice for me to talk to a therapist who's got different training than I do, different insight than I do, and is looking at what this child is saying, how this child's being impacted. And I don't get that kind of insight. I may not understand from a child what they're feeling. I just may get answers from a child. It's critical. It's wonderful. The therapists have always been great every time I've spoken to one. So.
Well, yeah, and I think that's always helpful in cases anyway. And I always encourage, our parties, like the children need counseling, like they're going to go through a major change,
Sure.
anything there. But that's another way that, you can be obviously very helpful in one of these cases.
I will say something too about the therapist. Interestingly enough, in family law in Florida, the parents in a family law dispute, a family law, some kind of litigation, some kind of contentiousness, they are not permitted to waive the therapist privilege for their child for the therapist coming and testify in court. So they're prohibited from doing that. So this is kind of, in some cases, in many cases, this is the only way they're going to get evidence, testimony, statements from a therapist before the court.
Yes, and and that we're about to go to the break, but that's a really big deal, and
Yes.
It's becoming more of an issue, right? That privilege that they have, the parent can't waive it, and that is important for kids. So, but there's got to be a balance, right? Because if somebody's ultimately making a decision on where they're going to be, therapist has a lot of insight into the child. So that's a really good point. Thank you so much for that one. But we're going to take a quick break again, Susannah, and when we come back, I really want to talk about relocation cases and how a social investigation can help with those, or when it's a modification, because a lot of times that's so necessary at that time. So while you wait, we encourage you to visit womenwinningdivorce.com, and you can also subscribe to the show, check out our resources, and we will be right back. All right, we are back with Susannah Collins discussing social investigations, and we're going to focus in this last section on modifications and relocation, because I think that's really important for our listeners to know, because I see a lot of those cases, right? Where maybe there wasn't a social investigation in the original divorce, and now things have changed because things change, right? And let's start with relocation, because Susannah, I think that is an area that I have found to be very, very helpful to have a social investigation in order to prevail on a relocation case.
So and I would say for both of them, and where we are in Northeast Florida, we have a lot of people who want to relocate because they might marry somebody who's in the military. Yeah. Mm-hmm. So that comes up a lot. And social investigations, in order to relocate, and we're talking about a relocation case, somebody wants to relocate more than 50 miles from where they currently live, or where they lived when they got the divorce. So this is not that, they're moving from the beach to the west side. This is actually something more significant than that. And so when they want to apply to the court for relocation because their ex-spouse says, there's no way in the world I'm agreeing to that, the court's really, really at that point looking at several different factors that are statutory. They're in the laws that say, well, court, you must look at, is this filed in good faith? Does the mom or the dad Do they really have an interest in doing what's in the child's best interest? This isn't just to, take the child away from the other parent, but what else is going on? And the court then starts looking at all of these factors, which get even harder to present to the court without a neutral third party, because the court says, what's the child's relationship with grandma and grandpa? What's the child's relationship with siblings, step siblings, friends? What are they doing in school? How entrenched are they in their community and sports, and et cetera, et cetera. So the court is really at that point not looking at anything else in the case between these parties except for the child's best interest and what the child needs. So when you have a case where dad's not very involved in the child's life and mom says, I'm going to move to Utah, dad says, there's no way you're going. Well, gosh, the court's going to look at, wait, how involved has dad been in the last 2 or 3 years since the divorce? Is dad current in child support? That's easy. We don't need a third party for that. But how's the child doing in school? Is there a better program in Utah for the child? Or their parents, extended family in Utah? All of these other factors, and there's no way that you can get all of that in front of the court for the child's best interest in a 4-hour hearing. And guess what? When you've got a relocation, you're not getting 5 days on the court's calendar. You're getting a minimum amount of time, because in the relocation statute in Florida law, if somebody wants to move temporarily, the court has to have a hearing within 30 days. Holy cow. If someone wants to move permanently, the court has to have a hearing within 90 days. So you've got to get somebody in there who can come into the court and present all of this evidence in one lump, just to make it easy for the court, because it is really, really difficult to get a hearing on the court's calendar within 90 days. And we all know that. Someone comes to you and they say, Heather, I need this to happen immediately. Just try to get scheduling on the court's calendar in 90 days, and you don't have a lot of time. So really hard to get all of these other people, all this evidence, everything compiled. Very easy for people to have a social investigator come in and say, let's check out the school system in Utah. Let's check out where mom might live. Let's check out how the child's doing in school here. Is there an IEP here that the child can get there? Are there doctors here that the child can see there? All of those kinds of things really impact a decision for the court. It's not just about whether or not mom or dad is remarried, or mom or dad has a new job opportunity. It's the child. And that's the most critical thing, because we take it out completely. He said, she said, what he wants, what she wants. It's really about the child. So.
Yeah. And I think that, also, we have people who then may remarry with military, or also that's why they're here because of the military. And then circumstances may change, and now they find themselves here with no family, and maybe there's not as much support from your ex. So, you think, well, I may want to move back where I have more support, or your ex may still be active duty and not here. So, I've had many people come to us and it's like, well, who's in that location, right? Because I've got the list of 20 things that we've got to answer before we even decide if we're going to move forward. And, also just for our listeners, when you are wanting to really, you need to know where you're going to live. Absolutely. Oh, I just want to move to Alabama. No, You need to know what street, where in Alabama and Birmingham or whatever.
You are correct.
And what school, and so specific.
Yes.
Because that's the only way to have a chance. And it can be very difficult. We have these conversations with women all the time, and we say, okay, well, you tell me everything. We have to pull out all the facts, because one fact in and of itself may not be enough, but it's that whole story, that entire, instance, which again, you said, Susannah, that then we say, okay, well, we've got a lot here. Now, how are we going to get all of this in front of the judge?
Absolutely.
Within our time constraints, where bringing in another person is helpful.
And I'll tell you, the difference between relocation, I know you're going to talk about this and ask me a question about this, but the difference between relocating and just modifying is the best interest of the child. Mm-hmm. So, that is the predominant factor. So it has to be the school, the education, the family, the support, the job opportunities, this whole totality of everything for the child. So. Right,
because as you and I both know, but for our listeners, the courts will say, hey, we know it's in mom's best interest, right? Because there's a job, or it's a new, husband or things, but we've got to separate that. And, because I don't make decisions where, I would say, hey, if mom's good, everybody's good. And that's just me, that's one part of it, because
Right.
if it is seriously going to impact that child's relationship with their father, their other parent, you're not going to prevail. Like, it's just really, the courts take it very seriously, and so we have a huge burden, and
Yes.
and there really needs to be, everything really needs to align.
It really does, because what
Get
you
there.
don't want to have happen is the court say, well, mom, this is great that you got remarried. Go ahead and move to Seattle with your new husband, but the child stays here. It's really important. It's critical to get somebody who can come in and say, here's how the child will be damaged if child doesn't go. Here are all the things that work for the child. So it's really critical in a relocation.
And it is, because, I know people listening, will probably be shocked, but it's true. It's just not a slam dunk. Like, it's not just because you're remarried. It could be this great relationship, additional children, and but unless somebody is there who can be, the expert, the one appointed to tell the court about this relationship and the bonds, and that you can't, break up this family, they might tell you you can't go, and that can be very devastating.
Sure. And mom's got to also, if mom's the one leaving, whomever's leaving also has to have a plan for how they're going to make sure the child continues that relationship with the other parent. It's a really big deal. It's a really big deal.
Is. And we've and we've talked to people, and sometimes, the father of the child has a job which he could live anywhere. That's a big deal. That matters, right? Because not that the judge can force them, but they can say, well, you could be, there too if you want. And the factors seem to support that. But you also have to know going into this, you better be willing to buy the plane tickets and make sure that the child gets extra time, or everything and anything you can do to facilitate your child's relationship with that other parent is critical in order to prevail on this.
And all of that has to be given to the court on a silver platter.
Mm-hmm. Mm-hmm. Absolutely. Now let's talk about modification, because I would say that often we'll have a case where they're wanting to make the change, and something's happened unanticipated, and they're like, we need to change the time sharing arrangement, and now we got to go back to court. And that's another situation where, without a social investigation, there's really going to be very little evidence that the court's going to have.
So this is the one I'm really excited to talk about, and because I think this is really critical. I have so many women who will say to me, oh, well, I'll just change the time sharing. Oh, well, it's just not working. This isn't working for the child. Well, guess what? I tell clients all the time, one of the very hardest things for you to modify under Florida law is a time sharing schedule. That whole parenting plan, I mean, you've got to have a lot. So when I talk about a relocation statute, the court's looking at the child's best interest. That's always a factor. But to modify a parenting plan, the best interest of the child, you don't even get to that step as number one. Number one, you have to prove to the court, not just say it, but prove to the court that there's been a substantial and material change in circumstances since the original parenting plan came into place. So substantial material change in circumstances, it's a heavy, heavy burden. The next step is you have to prove to the court that whatever those changes are were totally unanticipated. There was no idea that that possibly could have happened when you came up with that parenting plan, or when the court established the parenting plan. And, those are very, very heavy burdens. So I have clients who might be able to prove one, but not the other. You got to have them both. And if you can prove both of those, holy cow, then you get to step 3 that, okay, now we're looking at the best interest of the child. Well, for women, we all say, whoa, wait a second. Best interest of the child, that's the number one factor. It's not. When you're originally establishing the parenting plan, yep, we're looking at best interest. If you want to relocate, now you're going to impact somebody's time sharing because of this huge move. Yep, best interest. But for day-to-day purposes, our clients who are still living in Jacksonville, our clients who are still living in Nassau County or St. Johns County, they just want to change it because child's not getting to school on time, child's grades are failing, child's moving back and forth all the time. There's a new girlfriend, there's a new boyfriend, there's a whatever. It's not enough. It is a huge, heavy burden. And that's when, even if there wasn't a session investigation done the first time around, the courts often order them for modification cases. And in fact, if there's not one the first time around, the courts are more willing to order one the second time around for modification. So when you come in for modification, you've got to have somebody who understands the law, who's coming in as a third party saying, well, is it enough? Is the burden met? Is it, and a social investigator has some powers that a normal attorney doesn't. I say that because I'm a normal attorney too, so I get to say that. But so
you're an exceptional attorney today. You're not just a normal attorney.
Thank you for saying that. But it's not enough for me as an attorney, as the litigator, as counsel for somebody to say, Your Honor, the child's no longer 2. He's 14. Mm-hmm. Well, we all know, come on, we all know a child is 2 and a child is 14. We got some big changes there. That's not enough from an attorney. It's enough from a social investigator when you say, now let me tell you all the impacts. Let me tell you what I've seen. Let me tell you what the child's going through. Let me tell you about all of these things. And I can do A through T factors in the Florida statutes, how it's in the child's best interest, how things have changed, how it really has been a substantial material change in circumstances. But I will tell people truthfully that unless you get a social investigation in a modification case, you can almost guarantee it's not going to happen. So that's how important it is.
Yeah, and I really appreciate that, because it's sometimes, they think clients, I mean, I don't know. I have no idea really what they think, but I'm sure they think, well, come on, no, you're the attorney, you can do it. And like you've said, I may know this information, but I know it only from you, frankly, and right. I don't get to testify in court. We have to bring in the other people who can talk to the court, and it's so powerful and valuable. And it's not like you just read your report, right? You already talked earlier at the very beginning of the show, some of your reports are over 100 pages, but the court will read it, but then we can ask you questions and highlight, and the judge often, I've seen, ask questions themselves that they want to know, even if the attorneys didn't cover them all. And even if somebody's, unrepresented, the judge is going to ask questions that they feel maybe weren't addressed.
When I testify, I always get answers from the judges. Questions from the judges. They are always, they're always saying, Ms. Collins, what about X? What about Y? And, I tell people all the time when I testify in court, probably because I'm a litigator by nature. I mean, maybe not nurture, but by nature, I'm a very aggressive testifier. I aggressively want my judge to hear what I'm saying and do what I want my judge to do. So, there is a lot of that too. It's not just saying, oh, hey, I did this report. Here it is. You can read it on your own. But it's no, pay attention. This is what's really important. And I think that's, it's invaluable to clients in cases, really invaluable.
I think so. And, as we wrap up, there's a lot of value to you as a lawyer doing the social investigation.
Yes.
Because we do have a lot of individuals who do them who are in the mental health area. And I think there are some cases where they can do more because of maybe testing, maybe certain things that are really going on that need to be done. But at the end of the day, understanding the legalities, I think as a lawyer, you offer the court a little bit more.
I think so too.
That helps them make that decision.
Yes. And if there are really, really implications of mental health issues, it should go to a psychologist, a psychiatrist, really and truly. But if you are just applying the law, it's a really good thing to have a lawyer coming in and talking to the court. So, absolutely. Yeah.
Okay. But lastly, as we are wrapping up, Susannah, now before you go, I do have to ask if you can impart on our listeners what you have learned throughout your career about divorce and representing women specifically.
Oh my gosh, absolutely. Absolutely. This, I hope, does not come across terribly to anybody who's not a woman listening to this, but I will tell you this. In divorces, in my experience, and I've only been doing it for about 21 years, but in my experience, women care about the children, the child issues, best interests of the child, what the child needs, schooling, all of these things, and men focus on the stuff. And it's a terrible thing to say, but women, and truly, it just seems to be the most important thing to women is protecting the children, making sure they're happy, doing the right thing for them. And I could say that anywhere, anytime, in any body of company, because it's the truth. women really care about their children, and men do too. I don't want to say that they don't, but that usually seems to be the difference in a divorce. Men are trying to protect assets and women are trying to protect children.
Well, thank you very much for that insight. I so appreciate it. And we've reached the end of our show. Thank you so much to my guest this week, Susannah Collins. It has been a pleasure talking with you, and I know we will ask you to come back in the future. We'll come up with another topic. But for our listeners, you can find out more about Susannah at robinsoncollins.com. And her bio and social links will be provided in our show notes. And if this content was helpful to you, we would ask that you leave us a review so that other women can find out about our podcast. Thank you.
Thank you for joining me for this episode of Women Winning Divorce. My goal is to elevate your life and the way you are thinking so that you are best equipped to win at life. If you enjoy the show, please subscribe so you automatically get my new shows every week. And I would love to hear from you personally. Come join the conversation on social and join our Facebook group, Women Winning Divorce. We welcome your comments and suggestions. We want to bring you content that helps move your life forward. Women Winning Divorce is the place for an elevated conversation on how women can thrive during times of adversity in order to live their best life.